All right, the people of the state of Michigan versus Michael Todd Kurth Jr. These are files 21-23728, 21-23801, 21-23802. Mr. Kurth is here with his attorney, Mr. George, who will represent him on all these cases, and Mr. Marvin is the prosecuting attorney. I'm told that these are going to be resolved with a plea. So, Mr. Kurth, please raise your right hand. You solemnly swear or affirm the testimony you give will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. And so in our discussions before we started, I was told that in 21-23728, Mr. Kurth will plead to a charge of attempted carrying a concealed weapon. It's a crime punishable by up to 2 years in prison or $1,000. Court shall order enforcement to collect DNA. The charge of carrying a concealed weapon would be dismissed, and the habitual offender second offense notice would be dismissed. And then file 21-23801 would be dismissed in its entirety, and in 21-23802 he would plead to a charge of larceny over $1,000 but less than $20,000. They would dismiss the habitual offender notice, and Mr. Kurth would pay restitution on all, and the prosecutor would also recommend that the minimum sentence does not exceed 1 year. Is that your understanding, Mr. George?
Yes, Your Honor.
Mr. Kurth?
Yes, sir.
And did I say that correctly, Mr. Marvin?
Yes, you did.
What's the problem?
Did you say you want DNA on him?
No, I said it's subject to DNA.
Oh, I'm sorry.
Okay, so Mr. Kurth, in file 21-23728, on the charge of attempted carrying a concealed weapon, a crime punishable by up to 2 years. Now it's labeled a high court misdemeanor, but it's a felony. Anything punishable by more than 1 year is a felony. Procedurally, it's treated as a felony. It counts as a previous felony if convicted of a new charge. Just so you're aware, it's a little false to say that it's a high court misdemeanor when it's treated procedurally as a felony, but that's what the legislature calls it. So do you understand that part? Don't be confused. This is not a misdemeanor. It would be a felony. Do you understand that?
Yes, sir.
Okay. And so how do you plead to the charge of attempted carrying a concealed weapon?
Guilty.
Has anyone promised you anything to get you to admit to or to plead to the charge in this case?
No, sir.
Has anyone threatened you to make you do so?
No, sir.
Are you doing it of your own free will?
Yes, sir.
And you understand that if I accept your plea, you'll not have a trial of any kind. You'll be giving up the right you would have had at trial. Those include the right to be tried by a jury, to be presumed innocent until proved guilty, to have the prosecutor prove beyond a reasonable doubt that you are guilty, to have the witnesses against you appear at trial, to question the witnesses that appear against you, to have the court order witnesses you have for the defense to appear at trial. You have the right to remain silent during the trial and to not have that silence used against you, or if you want, you can testify at trial. Now, do you understand those are all your trial rights that you're giving up by pleading guilty?
Yes, sir.
You also understand that if your plea is accepted, you may be giving up the right to appeal certain issues that would otherwise be appealable if you were convicted at trial. Further, any appeal from your conviction and sentence pursuant to the plea will be by application for leave and not by right. What that means is if you go to trial, then everything is appealable. If you're convicted after trial, everything is appealable. But when you plead guilty, your appeal is by leave, which means you can ask the Court of Appeals to look at the issues, but they don't have to. If they decide there's nothing there they need to look at, then they don't have to look at it at the same level as an appeal by right. Do you understand that?
Yes, sir.
You also understand that when you plead guilty to something, you're giving up any defenses that you could raise by pleading guilty. So you can't come and say, oh, but wait, it was self-defense or it was something else. You're waiving that by pleading guilty. If you want to protect all those potential defenses, if there are any, I'm not saying there are, but if there were any, then by pleading guilty, you're giving up those. Do you understand?
Yes, sir.
Okay. So here it's alleged that on August 26, 2020, You are in the city of Three Rivers, the county of St. Joseph, in the state of Michigan. Is that true?
Yes, sir.
And here it's alleged it's originally alleged that you did carry a dangerous weapon and knife, whether concealed otherwise or in a vehicle operated by you in a Buick. So they charged this as an attempt. So what did you do that day that makes you guilty of this?
Well, I was moving out of my grandma's house, and I had a knife collection in my car, and the knife slid under my seat, and the cops walked up, and I had told them about it, but I'm a felon, so I'm not allowed to own a weapon like that.
Well, you're a felon and you can't have a pistol, but and you had an airsoft pistol in the front passenger seat. You also had a 16-inch long machete and a 15-inch long axe on the driver's floorboard. Both edge weapons were placed to be easily and quickly accessible by the driver when seated behind the wheel. So the allegation is that you had these weapons in the passenger seat of the vehicle, which is illegal. You can carry those if you want to put them in the trunk, but you can't carry them in the front passenger seat with you, or under your passenger seat, or under your driver's seat, where they're readily accessible but not obvious to anybody. So is that what happened?
Yes, sir.
Okay. Are counsel satisfied that there's a factual basis?
Yes.
Yes, Your Honor.
Are either counsel aware of any other promises, threats, or inducements?
No.
No, Your Honor.
Has the court complied with the court rule?
Yes.
Yes, the court has.
All right, I find the plea in that case was made knowingly, understandingly, and voluntarily, and there is a factual basis. Therefore, I accept the plea. Let's move on to 802. In this case, Mr. Kurth, you are charged with larceny over $1,000 but less than $20,000. The habitual offender notice would be dismissed. Now, larceny over $1,000 but less than $20,000 is a felony punishable by up to 5 years and/or a fine of up to $10,000 or 3 times the value of the property, whichever is greater. How do you plead to that charge?
Guilty, sir.
Has anyone promised anything else to get you to plead in this case?
No, sir.
Anybody threaten you?
No, sir.
And are you doing this of your own free will?
Yes, sir.
And again, you understand that you're giving up your trial rights by pleading guilty in this case, and I just described all those to you.
Yes, sir.
All right, here it's alleged that on April 9th of 2021, you were in White Pigeon Township, County of St. Joseph, in the state of Michigan. Is that true?
Yes, sir.
And here it's alleged that you did commit the offense of larceny by stealing a trailer with 4 snowmobiles that belonged to another, and the value of the property was over $1,000 but less than $20,000. What happened that makes you guilty of that?
I pulled up and hooked up to the trailer of the snowmobiles and tried to leave with the trailer on my truck.
Okay. And they weren't your snowmobiles?
No, sir.
And I think we just took the co-defendant's plea in this. So you took off and the homeowner, the owner started following you?
Yes, sir.
And then you ended up getting in an accident and rolling the trailer and the snowmobiles trying to get away from the person?
Yeah.
Okay. Counsel satisfied there's a factual basis?
Yes.
Yes, Your Honor.
Are either counsel aware of any other promises, threats, or inducements?
Aware of none.
No, Your Honor.
Has the court complied with the court rule?
Yes.
Yes, the court has.
I find the plea made as accurate, understanding, voluntary. There's a factual basis, therefore I accept the plea. We'll set these for sentencing on what day?
Friday, July 9th.
July 9th. All right, bonds canceled. We'll see you back here on July 9th. Mr. Kurth, get that packet filled out so they can update your pre-sentence report, and we'll see you back here on July 9th for sentencing. All right, thank you very much.
Thank you, sir.